Our second academic on the panel who's going to address you is Dr. Fergus Ryan. Fergus is an expert on law and its relation to family, gender and sexual orientation. He lectures, as many of you will know, in NUI Maynooth, and as an academic and an activist during the Yes Equality campaign, Fergus is going to have a look at, firstly, what are maybe the rights that the marriage equality referendum has actually delivered to LGBT people, what remains to be done, and then perhaps looking at the use of legislative equality and its significance for social campaigners, which I think will have resonance for many of you here who are looking at, should we be using referendum, should we be taking the legislative route, and I think he has some interesting things to say on that. Thanks very much, Fergus.
Thank you very much, Grania. Thank you for inviting me. I'm delighted to be here. Thanks. I have a PowerPoint which is as much to keep me on the straight and narrow and to prevent me from rambling as anything else, but I want to talk about, I suppose, a few aspects of the referendum experience as they relate to law, and also to offer a little bit of context as well from a legal perspective. And I appreciate that it's a somewhat narrow perspective, but I think it is one part, but only one part of the picture. So my aim, I suppose, in the time that I have is briefly to evaluate the legal implications of the referendum result, and in particular to identify, not to be negative, but to identify perhaps some of the loose ends, the things that still need to be done. So I would, in particular, like to highlight some of the further reforms that might be worth considering. I suppose to point out this is not the end of the reform story. I also wanted to offer some brief thoughts on law reform routes, in particular the role of a referendum. And again, as several people have said already, the value of avoiding a referendum on these kind of issues where possible. Just that's a picture there actually of when the bus, the marriage bus visited Maynooth. Holding a large pencil, I discovered is very slimming, so you kind of it's a very good strategy. But that was just to give you a sense of some of the flavour, if you like, and the colour of the referendum experience in Ireland. It was a wonderfully colourful, joyous experience, albeit also a very nerve-wracking and anxious experience. And I say particularly the older you are, if I can say this, if it's not impolite to say it, the older a person was, the more they could remember the bad old days, the 60s and 70s, the more anxious, the more stressful it was. The law prior to 2015 wasn't all that bad, one has to say, for LGBT people. I think it's important to note that while we only had decriminalisation in 1993, so we came quite late to that particular event, so it was a criminal offence to engage in most forms of male homosexual sexual acts until 1993 in Ireland. But actually since then we've come quite a long way very quickly. I think it's fair to say that by the mid-1990s that as individuals, lesbian and gay people, less so transgender people, that took a lot longer to reform. But in relation to lesbian and gay people as individuals, there were a lot of protections put in place in the 1990s, particularly around employment equality, unfair dismissals, refugee status and so on. But as couples, there was very little protection up to 2011, that couples, although individual LGBT people had a lot of protections as individuals, as couples we had very little recognition up to 2011. Most critically, prior to 2015, same-sex couples were not permitted to marry in Ireland, and this was copper-fastened by an act from 2004, the Civil Registration Act 2004. But at common law, it had always been unlawful to marry a person of the same sex. That marriages between parties of the same sex were void at common law for as I say, for a very long time. The 2004 Act copper fastened that as a matter of legislation, but this is really only confirming what the reality had been to that date. There was a constitutional right to marry prior to the referendum, but as the Zappone and Gilligan case illustrated, the decision in the High Court in the Zappone and Gilligan litigation confirmed that the constitutional right to marry, unfortunately, applied only to opposite-sex marriages. Now, one can quibble with that verdict, but that was the law as it stood up to 2015. Now, from 2011 to 2015, if you were in a marriage for a same-sex couple and you got married abroad, that would be recognised in Ireland, but only as a civil partnership, not as a marriage. I suppose a key aspect of this is the issue of constitutional recognition. While you can deliver, I suppose, significant rights through legislation, from a constitutional point of view, our Constitution in Article 41 protects the family, but it recognises only the family that is based on marriage. And so prior to 2015, same-sex couples, because they were excluded from marriage, were also, by definition, also excluded constitutional recognition and protection as families under Article 41. So while you could do an awful lot with legislation, the Constitution, which is the supreme law of the land subject to European Union law, only recognised families that were, and still only recognises families that are based on marriage. And because same-sex couples were excluded from marriage, this meant by definition that we could never be constitutional families. Now, it was possible from 2011 to 2015 for same-sex couples to enter into a civil partnership. Civil partnerships were confined to same-sex couples only. The process for entering into civil partnership, which actually was very similar to the process for entering into marriage. The two were pretty much the same, except for the point that whereas civil marriage can be celebrated in a religious venue, that's not possible for a civil partnership. So civil partnership was wholly secular in terms of the process for entering into it. Be that as it may, the rights of civil partners were largely the same and remain largely the same as the rights of married couples. The same-sex civil partners have most of the same legal rights and obligations as married couples, so you're almost as close as you possibly could be to being married without being married. However, there were some significant differences, some practical, but most mainly symbolic. And the symbolic, I don't mean to say that that's not important. The symbolic differences are critical. In particular, the lack of constitutional recognition and protection for civil partnerships. A very clear message was being sent out that, well, you may be a civil partner, but you're not quite there yet because you're not married. Only married couples enjoy constitutional protection. There were practical issues relating to children. While the civil partnership legislation provided most of the adult rights and obligations that were attached to marriage, I suppose the rights and obligations associated with the raising of children did not attach to civil partnership. There was a glass ceiling there of sorts, a reluctance to deal with same-sex couples raising children. So it was almost as if civil partnership, the rights and obligations were ring-fenced around adults, that the children being raised by civil partners until 2016 were out of the picture. It's also worth noting, and this might have been a positive, but it's easier to exit a civil partnership than a marriage. One constitutionally has to wait 4 out of the previous 5 years, to be living apart for 4 out of the previous 5 years to get a divorce. In Ireland, civil partnership is a much more reasonable living apart requirement. Now, it's interesting to look at the possibility of, I suppose, civil partnership being or having provided a gateway to marriage. Various people have suggested already that civil partnership provided a significant new legal and social status for individuals. You had formal legal recognition and legal respect, I think, implicitly for same-sex couples flowing from civil partnership. As Brian Sheehan mentioned this morning, it helps to normalise same-sex unions. From a practical point of view, it delivered really important legal rights and protections, particularly in the area of taxation. Civil partners and spouses are treated the same for taxation, for social welfare, for immigration. There are some slight differences, but in the area of succession and pensions, social security, and so on. And by doing that, by dealing with those practical issues, it removed all those issues from the marriage debate. There was no discussion, or very little discussion, around the taxation or social welfare or succession implications, because all those issues are already being dealt with by the civil partnership legislation. However, on the other hand, the difficulty with civil partnership, besides the point about the lack of constitutional recognition, you look into a constitution that is supposed to reflect your country and its values, and you don't see yourself there. You're not in there if you are not a heterosexual couple. So the lack of constitutional recognition was clearly an issue. The minimal recognition for children being raised by same-sex couples, although that has been rectified by the Children and Family Relationships Act. But I think the key issue was that for many people, civil partnership and the civil partnership regime was seen as copper fastening second-class citizenship. It certainly improved things considerably for lesbian and gay couples in terms of their options, but you couldn't escape the feeling that it was a kind of a consolation prize. It is worth noting that the No side capitalised on the rights delivered by civil partnership. One of their highly ironic, almost humorous posters was, we already have civil partnership. Various people who had opposed civil partnership tooth and nail suddenly were championing civil partnership as a wonderful thing, including some very prominent senators who I heard talking about the wonders of civil partnership when they had opposed it section by section when it went through the Seanad. So there are pluses and minuses certainly to civil partnership, although I think at Rouge it helped, I think, to create a new legal and social status, a sort of platform from which it became that bit easier to achieve marriage. So what has changed from a legal point of view? Well, we now actually have a constitutional right written into our Constitution. The 34th Amendment of the Constitution has inserted a new Article 41.4 into the Constitution. This creates and embeds a constitutional right to marry a person of the same sex, and the wording is there. It's important to note this is not a different type of marriage. The same marriage is available to opposite-sex couples. I think that's a given, but sometimes that's not appreciated. It's the same civil marriage regime. There are some interesting features that it for instance, copper fastens the ban on polygamy. I don't think that was something that was really noted to any great extent, but it's clear that the right here is a right for two persons, not more than two persons. And it also is implicit in the measure that same-sex and opposite-sex couples should be treated equally. Now, the Marriage Act 2015 helped to, I suppose, to tie up some of the loose ends associated with the marriage referendum, and in particular, it removed the formal ban on the marriage of same-sex couples that had been introduced by the 2004 Act. It also did various kind of housekeeping issues, like, for instance, it tidied up the issue of the prohibited degrees of relationship. Basically, a man is not allowed to marry his mother, therefore he's not allowed under this legislation to marry his father either. So the prohibited degrees of relationship for opposite-sex marriage were extended to equivalent relations of the same sex. It also notably copper-fastened the exemption for religious bodies. Religious bodies in Ireland can celebrate marriages that are recognised by the state. The legislation protects religious bodies. They cannot be compelled against their will to celebrate marriages of same-sex couples. Notably, and again, this is something that's not always noted, that this allows them, if they wish, to celebrate only the marriage of same-sex couples and not to marry opposite-sex couples if they wish to do so, although I don't see anyone jumping up for that particular option. While religious bodies can, if they wish, marry only one type of couple, they are free, basically, to marry only opposite-sex couples or only same-sex couples, but they can, if they wish, marry both, although I think there's comparatively few churches that are doing that. The legislation also makes provision for recognition of foreign same-sex marriages, which are now recognised in Ireland, subject to certain conditions as marriages in Ireland. Now, interestingly, the Marriage Act 2015 gradually phases out civil partnership, and I'd say you've heard this joke before. I possibly am the only person who's upset about this because I have a book on civil partnership that will never see a second edition. I think there isn't a great lament for the fall of civil partnership, but civil partnership will no longer be available to new entrants. It has no longer been available since November 2015. And while existing civil partners remain as civil partners, two people in a civil partnership with each other may marry each other with as little as 1 day's notice. And that last point is important. Normally, you've got to give 3 months' notice, which alarms people from abroad. But in the case of civil partners who are marrying each other, they only have to give 1 day's notice, which is an important provision. I think, so the demise civil partnership is one important feature, that effectively civil partnership as a phenomenon will gradually die out. One also important implication was that the adoption of marriage for same-sex couples effectively helped to remove the single status requirement from the Gender Recognition Act. The other great thing that happened last year is that Ireland finally adopted a very progressive Gender Recognition Act, allowing people who are transgender to be recognised in their preferred gender. The legislation initially had a single status requirement, which meant that you could not be married or in a civil partnership. That was removed in the wake of the marriage referendum. So that was one other important positive effect that the marriage referendum had. Now, there are a couple of loose ends. I mean, broadly speaking, there are very few loose ends left over. Same-sex married couples and opposite-sex married couples are treated the same for almost all purposes, but there are a number of areas where I think some tweaking is required. I can't go into all, I'm not going to go into all of them given the time constraints, but there are certain issues, particularly we've noted in recent weeks around adoptive leave provisions need to be amended to address the situation of same-sex married couples. There are assisted human reproduction provisions in the Children and Family Relationships Act that affect LGBT, particularly lesbian couples having children through assisted human reproduction. They have not yet been brought into force. There are some issues around pensions equality. Generally speaking, married same-sex, married opposite-sex couples are treated the same for the purpose of pensions, but there are some issues of potential pensions inequality for those who marry, who are only able to marry after or shortly before retirement under certain pension schemes. There are some issues there which are currently being dealt with by the Court of Justice of the EU. So just to wrap up, I suppose one of the key points I wanted to make is that while this is a very significant referendum, there are still some big questions from a constitutional point of view. In particular, it's important to note under the Constitution that while we have changed access to marriage, marriage still remains the sole touchstone for recognition as a family. So that does need to be addressed. The bigger question, I don't think it could have been, in fairness, I don't think it could have been addressed at this point in time perhaps, but at some point in time we are going to have to deal with the fact that our Constitution only recognises the family based on marriage. And in particular, unions that are not based on marriage continue to be subordinated under the Constitution and legislation. So while the marriage referendum is very welcome, it's not the end of the struggle for equality. And I think it's also worth pointing out that there are still vulnerable, marginalised LGBT people who continue to need our support and advocacy. And in particular, I think it's important to bear in mind that for poorer people, that marriage, as Ruth Colker has pointed out, may offer few economic advantages. So that it's worth, I suppose, bearing in mind the class implications of the introduction of marriage, that arguably we need to do a little bit more to include a wider category of people, but this is certainly a very, very good start. There's a couple of lessons there, one, many of which people have already pointed out. Beware the liberal radical echo chamber, beware preaching to the choir, you've got to win the middle ground. The other thing I want to say is that legal arguments on their own don't win referendums. So you want to win a referendum or an argument, don't just send out the lawyers, but the lawyers can help, in particular in dispelling a lot of the red herrings. There were a lot of red herrings during the referendum. So I'll leave it at that. Thank you very much. Sorry.